Hello everyone, welcome to Court with Krissy. Here are 4 short-ish court clips you probably didn't catch. And I'm kicking it off with my favorite. Gramps has a criminal record that is older than I am. He may be vintage, but he's still spicy. Judge has to mute him. I hope you like it. Court with Krissy is now in session.
Williams.
Person at the jail, what is your name?
Hold on, he's got to be able to
My
see.
name is John Osbozic.
I'll turn it up for you, but he's got to be able to see you, okay?
This is the people of the state of Michigan versus John Stephen Bozick, case number 251975SM. Mr. Bozick, what's a good mailing address for you?
Right now, I have 2 addresses. One of them is, did you get that?
I did, yeah. Is that in Luther?
Yes, sir.
And you receive mail at that address?
I received mail at that address. My neighbor picks up the mail.
Okay.
Because
And
I've had 3 strokes in the last 10 years. I had a heart attack in the last 3 weeks. And the property is on a Pine River with frontage, but it needs a new well, 10 grand, 4-inch well. It
So,
needs
Mr. Bozick,
it to 100 amps or 200 amps.
you said you had 2 addresses. What's your other address?
The other address is,
So
it is
which
a temporary address.
Okay, so if we were to mail you something, where would you want it mailed to?
That you let me talk, because I will give you the answer.
Well, I would appreciate it if you let me talk and answer my question. So if I'm going to send you a letter, where do I send it to?
You can send it to either or
Okay,
both.
okay. Now, did you have the opportunity to meet with somebody from the public defender's office today?
I sure did.
All right. Do you have a telephone number?
I have 2 numbers. One is a cell phone number that doesn't work all the time because they're a dead zone, don't reach the towers. That
Okay,
means
what's
when
that?
I'm away from the cabin, you're interrupt me again. I have a cell phone number that I can use away from the cabin. And that number is 23.
And if we were to contact you, is that the, now you're interrupting me. If we were to contact you, is that the number we contact you at?
It depends if I'm near the cabin or away from the cabin.
Okay, then what's your other telephone number?
The other telephone number is, I found a landline behind the couch where at one time it was serviced by AT&T, where I just continued that service, where now it is a telephone company I never heard of and you had never heard of, where it's a landline that's taken over out in the boony territories, and that number is
5062?
5262, sir.
5262, okay.
I'm at the cabin, I can use that. I can't use a cell phone until I get a mile away on the blacktop.
All right. Do you remember if you read and signed an advice of rights form at the jail, talked about your rights to an attorney and your rights to a trial?
I never had a chance to sign that because there was a female blonde officer that came there and gave it to me. Well, I knew what it was all about. And there was a shift change where she said she'd be back in 15 minutes, where I said, I'll sign it right now. She said, I want to make sure you read all of it. I'll be right back. She got busy with responsibilities that were more important, and she would think the second change would do it. But I never got it back. I never had a chance to sign it.
Okay, so I'm gonna go through those rights with you right now, all right?
Yes, sir.
If you require special accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you to fully participate in court proceedings, please contact the court immediately to make those arrangements. You have been brought to court on a misdemeanor charge and you have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with the permission of the court. You have the right to have a trial by jury and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, which means without money to hire an attorney, and the offense charge requires a minimum jail sentence, or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may be ordered to repay the expense of the appointed attorney. You can contest your ability to pay the ordered fees if the court attempts to collect the costs for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you'll be giving up the rights that we just went through. You have the right to be released on bond, and we'll get to that in a moment. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by a judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows for otherwise, for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. An appeal to the circuit court may be taken within 21 days from the date of sentence, or is permitted pursuant to court rule if the sentence includes incarceration. And if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days after sentencing. Federal law and or state law may prohibit you from possessing or purchasing ammunition or a firearm, including rifle, pistol, or revolver, if you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Sir, do you understand those rights that I just went through?
Not all of them, because I don't have my hearing aids. But I'll make this short and sweet. I definitely.
No, we're not going to make this short and sweet. There's a procedure I have to go through, and I'm going to follow that procedure.
I'm going to answer your questions in relation to what you just read.
Did you? Well, my question was, did you understand those rights?
I understand those rights, but I have an answer to some of those rights by law, which should be recorded. Now, can I tell you
those
why?
rights don't require an answer other than whether or not you understood them. So it sounds as if you understood them. This is not the time to answer questions about those rights other than if you understood them, and you indicated that you had. So I have a complaint that alleges that on or about May 19th, 2025, here in the city of Cadillac of Wexford County, It is alleged in count number 1 that you did disturb the peace at Munson Hospital. That is a 90-day misdemeanor and or a fine of $500. Do you understand those charges and the potential penalties?
They're absolutely false.
My question was, do you understand the charges, not that you agree with them?
Absolutely.
Okay. You have the right to be represented by an attorney at all phases throughout this process. And if you could not afford an attorney, one would be appointed to you a public expense, but you may be required to repay a portion of that expense. Do you understand that?
Yes, sir.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I'm gonna try to save some money where the taxpayers will pay for a court-appointed attorney.
So you want the court to appoint an attorney?
I would like to pick and choose my own.
Well, your choices today are that you hire an attorney or that you request the appointment of an attorney. So are you telling me you want to hire an attorney?
I want to get a court-appointed attorney where if he doesn't do the job, I'll fire him. And I will prolong the court for 9 months by firing several court-appointed attorneys that get paid for every case where they don't represent you properly.
Mr. Bozak, it's clear you don't understand how this process works. You don't get that option. The court makes a referral to the public defender's office for the appointment of an attorney. That appointed attorney will represent you. Only for certain reasons can I release that attorney. You have made the request for an appointment of an attorney, so we will make the appointment of an attorney, enter a not guilty plea on your behalf, and we'll set the matter for a pretrial. If something happens that you're not happy with the service of the court-appointed attorney, you are always able to hire your own attorney. At that pretrial conference, your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. I have received the praxis in this matter. It is scored at a 3. I take issue with the history of violent convictions, and we'll go through that in a moment, but I think that should be scored at a 1. But I will give him credit for the fact that he is resident. So I think in the end it washes out and will stay at 3. But in the defendant's prior history, I show in 1979 a malicious destruction of property over $100. In 1990, an attempted false pretense. 96, a larceny by conversion over $100. 98, an aggravated domestic and an OWI. I'm sorry, 98, an aggravated domestic. 98, a domestic. 01, operating while intoxicated. 01, CSC 2. 13, failed to comply with reporting duties. 14, larceny less than $200. 14, resist and obstruct a police officer. 15, stalking. 16, OWI third. 17, operating without security and driving the license suspended. 18, failed to comply with SORA. 18, a trespass. I also show that the defendant is currently on bond in Lake County for an operating while intoxicated 3rd offense. Mr. Hartel, any comment regarding bond?
Yes, Your Honor. I'm not sure if these allegations here will lead to any bond issues with Lake City. I don't know if they're going to place a hold on him. I don't know because I haven't heard anything of that nature. I'll presume not. I would ask the court to at least consider a personal recognizance bond. I presume, if I said Lake City, I meant Lake County. I presume with the OWI third, they're going to be requiring some form of drug and alcohol testing. I don't know if that was alleged in this incident or not. I presume some of that's going on with their bond conditions. I believe that any concern for public safety can be overcome with bond conditions. I'm cautious to say that he could avoid going to the hospital. He is older. He does have health conditions. I'd ask the court not to limit him from seeking medical treatment, but I do believe a bond condition of no harassing or threatening behavior, no disturbing of the peace. I think something along those lines would be appropriate, but especially knowing that he does have other bond conditions in play, I'd ask the court to consider a PR bond. Thank you.
Ms. Lawrence.
Thank you, Your Honor. As you just went over, the defendant does have an extremely lengthy criminal history. It looks like in this case, he wasn't at the hospital and was refusing treatment. Upon arrival, he was causing a scene, he was yelling profanities. He was also blocking an ambulance who was trying to get into the bay to bring a patient into the ER. And it also says that troopers tried for approximately 3 hours to work with him, to get him a ride, to get him to leave, and he would not listen. So for all of these reasons, we do think this is a concern for public safety, and we would be asking for a $2,500 bond.
He was at the hospital refusing treatment?
That's what it reports, yes. He was,
They're all false. They're
it
lies.
says he refused.
Jail, I'm
treatment.
gonna mute you.
It said he refused treatment and then he was refusing to leave.
All right. Mr. Bozak, I'm going to impose the following bond conditions on you. I'm going to order that you appear as ordered, keep your contact information current with the state, with the court and your attorney, and to commit no new crimes. I'm also going to order that you not have contact with the Munson Hospital here in Cadillac. I do find that the defendant being on bond in Lake County for operating while intoxicated, and then the allegations presented to the court today, I do find that the defendant is a threat. Bond will be set at $1,500 cash surety under those conditions. Anything else, Mr. Hartel?
No, thank you.
Ms. Lawrence?
No, no.
Thank you, Jail.
I'm going to go ahead and mute back up. Might this be April Lynn Lyman?
Yes, Your Honor.
April Lyman, you want to face me? But I have the officer in charge to try to motivate April Lyman to face the court. All right, April Lyman, do you respond, please? Apparently, she's not going to. This is State of Kansas versus April Lynn Lyman. It's case number 2024, CR 396. April Lyman, silent as she is, appears at the Butler County Detention Center Zoom location. Cheryl Pierce appears on behalf of the state of Kansas. I will note, docket notes would indicate defendant pled guilty to possession of marijuana and possession of drug paraphernalia before this court back on March the 4th. Has there been an action taken on her sentence by a warrant to show cause, Ms. Pierce?
Yes, Your Honor. It looks like there was a warrant to show cause.
I do not have that document before me. Maybe it was very recently filed. I don't know. So what are the allegations of the warrant to show cause?
So it looks like it was filed on April the 21st. It looks like it's failed to report as directed, failed to make monthly payments, failed to complete a drug and alcohol evaluation and follow the recommendation, and failed to report immediate or failed to report law enforcement contact immediately or the next day, and failed to report all changes in address. It goes on to say has not reported, has not made any payments, not provided any proof of drug and alcohol evaluation, has had law enforcement contact and failed to report that, and has failed to keep her address current.
All right. In short, after you've read off those allegations in the warrant to show cause, it would appear, Ms. Lyman, that it's alleged that you haven't done anything that you were supposed to do on your probation. Further hearing will need to be set in regards to these allegations, however, before this court. This court's next docket for that purpose would be June 6, 2025, 2:30 p.m. You are required to fully participate in this court's docket at that time. June 6, 2:30 p.m. If you do make bond, you must appear for court at the Butler County Judicial Center in El Dorado, Kansas, and no other location. And report to your officer as directed between the time that you make bond and the time of the hearing. Mr. Lyman, are you hearing, Ms. Lyman, are you hearing anything that the court's saying here?
I believe she is, Your Honor.
Ms. Lyman, what game are you playing here? Because it's not helping you. All right, let the record reflect that Ms. Lyman has just turned away from the court, refuses to respond to any statements or questions asked by this court. What was the bond established on the warrant to show cause?
$2,000 cash or surety.
Just given the defendant's total reticence to even cooperate in any way with the court is going to raise that bond in this case. I think she's a much greater risk than originally anticipated. Court will raise that bond to $10,000, cash or professional surety required. The court just perceives an utter lack of response by Ms. Lyman, no explanation for it. She doesn't report to her officer as directed and really hasn't done anything, as the court noted, on her probation. A considerable risk of flight exists in this case. Court has no confidence that she'll appear for court when directed to do so. So I want to have a substantial bond backed by a surety if she does get out. Our court date again is June 6, 2:30 p.m. Court will appoint a lawyer to represent Ms. Lyman. Darren Patterson will be appointed. We've set our court date, appointed counsel, and the bond has now been reset by the court. I'll ask the question, though I expect to get no response. Ms. Lyman, is there anything else that you need to address the court about? No response as before. Ms. Pierce, anything further at this time?
No, Your Honor.
The April Lyman matter will be in recess at this time, and she can be taken back to her cell.
We're addressing Clements versus Kuhan and Williamson. Ms. Williamson is present. Mr. Kuhan is present. They were both sworn. Ms. Clements was sworn. Ms. Williamson apparently was not personally served, but she is present. And she's going to get her acknowledgement of the rights, and she was sworn, so she is a party. In small claims court, the claim is limited to $7,000. Neither party is allowed to have an attorney. There's no formal record being made of small claims. We don't strictly follow the rules of evidence or procedure. We'll allow hearsay. We won't have a lot of foundational fights about admissibility of documents and that sort of thing, like phone records or those sorts of things. And there is no appeal from small claims. Any decision made here is final. Either party has the right to remove the matter from the small claims division to the general division of the court. You have to tell me that before we begin. Ms. Clements, are you ready to go?
Yes, I am.
Mr. Kuhan, are you ready?
Yes, Your Honor.
And Ms. Williamson?
Yes, Your Honor.
All right. This is a family matter, and I wish I wasn't here.
Me too.
But it's a claim for $2,000. Ms. Clements contends that she, on two separate occasions, lent $1,500 to the defendants. And the defendant is her son and his girlfriend.
Correct.
You contend that on November 16th, you lent him $1,500. And on December 30th, you lent him another $1,500 for a total of $3,000. Is that correct?
No, it's not. August 21st, he texted me for the first $1,500.
It was August 21st. Okay.
Yes. And it was November 16th. I was personally asked when I went to stay with them.
All right. So you gave them $3,000. Now, as a part of this, you also moved into their house.
Yes. I went and stayed with them for about 6 weeks.
And you were to pay $250 a month in rent?
I offered them $500 and they said that was too much. They said $250 will be enough. And I paid them $250.
All right. So you paid November, but not December.
Correct.
All right. So, Mr. Kuhan, that's her claim that she lent you $3,000, you paid back $1,000, she may owe you $250 for rent. You countersued for a bunch of stuff you can't sue for in small claims court. You can't sue for defamation of character, slander, or financial distress in a small claims proceeding. They don't do tort cases in small claims court. It's strictly money. So she says she lent you $3,000, you paid back $1,000, and it appears she didn't pay December's rent. You go through a bunch of other stuff about how unpleasant the stay was while she was there. But what can you tell me about these loans?
So let's see. So most of these were before she moved in, and then she ended up moving in. She really didn't help with anything.
Well,
She did.
We'll get to that in a minute. Did
Okay.
she lend you $1,500 on November 16th?
Yes.
And did she lend you another $1,500 on August 21st?
That I'm not sure. But she did not send it to me. It was never sent to me, which is why I'm all confused. It wasn't sent to me. That's not my Cash App. I'm assuming it's my wife or my fiance's.
Miss Williamson?
Yes.
So did you get one of these $1,500 ones, Ms. Williamson?
I got them all. But I never asked them for any money.
Okay. All right. So did you guys pay her back $1,000 after you got some sort of secured loan?
Yes, Your Honor.
Okay, very good. So we're arguing about $2,000. Now there's this also issue about $250 a month rent. So she paid November, but not December. All right, now, Mr. Kuhan, what are the other things you wanted to tell me?
The destroying our property that we rent. Our front yard tore up with tire marks. I'm assuming she put her car up to our front door to load all of her stuff and like ripped up all of our grass. So we had to pay to fix that.
How much was that?
Oh yeah, yep. Well, I don't know, about $300 for the seed and everything else that we needed.
If you bought $300 worth of grass seed, you could grow 2 acres of property. How much? I don't want you to throw something at the wall and see if it sticks. I want you to tell me how much this cost.
We're not 100% sure. We're not done fixing it yet.
All right.
We work a lot.
Okay,
Sorry.
what
Sorry, Your
else
Honor.
is, you're fine.
She also left her unemployed brother with us that we had to take care of.
Who is an alcoholic.
All right. What else would you like me to know?
She called CPS on us for no reason. She called DHS on us for no reason. All of my stuff is under review. I have to say, Your Honor, that I work in healthcare, so I could potentially lose my job for what she's doing.
And that's in your pleadings. Then she responds back. I want to try to stay out of the weeds. This is family stuff, and frankly, I'm
100%
embarrassed
agree.
to be here.
I
This is
am
a
too.
small claim. But she lent you money. You paid 1/3 of it back. It's offset by the rent she failed to pay. And you can't sue. You can sue for these things, I suppose, but you can't sue in small claims court for defamation, slander, those other things. They're hard to put money damages on. And they aren't compensable in a small claims proceeding. And so there's certainly lots of bad feelings. So, and it certainly didn't engender any good feelings. She's mad at you because you didn't pay the money. She turns you into CPS. She turns you into DHS for food stamp fraud. This other guy gets left there and you're got him, but I'm not sure she's liable for that in a legal sense.
Sorry, Your Honor. They had a choice to either remove him from the house or I would leave. He came home drunk, calling me an effing C word, like my son had called me. And so I gave him a choice. He leaves or I leave. And they didn't leave. They didn't make him leave, so I left.
We wanted you to leave.
Honor your own will.
All right.
We tried to work it out with everyone.
Tried, but everybody's so
The
hateful.
reason why we're here is because
everybody's
of us
so
trying to
angry.
help her out. Of us trying to help her out, and now we're stuck with this. I'm sorry, Your Honor, but we can't give her things when we're not making money. We have no money. I'm still paying the bills off from when she left us. I mean, you can clearly see the gas bill went from $200 to $700. I can't afford that.
Because she was home here
all day long
while we're at work.
Your Honor,
She's always complaining that it's cold.
I looked at the bills, Your Honor, and I know how to add. So
Well,
I see
listen,
that.
I didn't ask you a question. I tried to admonish everybody that we're in a court proceeding. We're not sitting around the kitchen table. But presumably for the privilege of living there, she was to pay rent, which would have, I guess, gone toward some of those other expenses. If you want to file a direct claim against her rather than a counterclaim, you can do that. But I find that she owes $2,000. You owe $2,000 less the $250, so he owes $1,750. Mr. Kuhan and Miss Williamson are liable for that amount.
Your Honor, I have a question. Technically, can she file in your county since this happened in Macomb County?
I was trying to determine this.
You can't.
She has a Marcellus address. This all went down in Roseville.
Macomb County, yes, Your Honor.
All right, jurisdiction is either Macomb County or here. And although her address is Marcellus, which is Cass County by mailing address, the property is this side of the county line out on M216. So perhaps I would have been really happy if this had been filed in Macomb County, but it was filed here and jurisdiction is at either end. Even though it is a Marcellus address, she's a St. Joseph County resident. So perhaps if you wish to file a direct lawsuit against her, you can file it in Macomb County. It won't be heard by a judge there. It would be heard by a magistrate. Anyway, the court costs are $192.50. $1,750 plus $192. 0.50. 1,942.50. You have 30 days to pay this, or she can pursue collection. Now, if you wish to file a direct lawsuit for these other things, including gas bills or defamation or slander or those sorts of things, you can do that. Some of those things would have to, you probably could use an attorney's help. But if you want to sue just for money damages, you can do it in small claims in Macomb County or here in St. Joseph County. But I make a finding that there was a loan, 2 separate $1,500 loans. 1,000 repaid. December's rent was not paid, so I've deducted that. 1,750 plus cost, 1,942.50. And I'll send each of you a copy of that judgment.
Thank you.
All right, good luck.
Thank you, Your Honor.
Thank you.
Good afternoon. Are you Gary Stephen Weaver?
This is Gary Weaver, Your Honor.
It is.
Okay. I'm Judge Satterfield. I'm here to advise you that you have been charged by the prosecutor's office, the Butler County Attorney, with stalking, a level 9 person felony. It is alleged that on or about the 18th day of April 2025 through the 16th day of May 2025 in Butler County, Kansas, that you did unlawfully, after being served with notice of a protection order, prohibiting contact with the targeted person, to wit, Kathy Weaver, in Butler County case number 25 DM 127, recklessly engaged in at least one act listed in F1 that violated the provisions of the order and would cause a reasonable person to fear for such person's safety or the safety of a member of such person's immediate family. So this involves a violation of a restraining order and at least one threat against a Kathy Weaver. A level 9 stalking carries a possible sentence, if convicted, of anywhere from 5 months up to 17 months with the Department of Corrections and up to $100,000 fine. I'm going to enter a not guilty plea for you since this is a felony. I want to ascertain whether or not you can afford an attorney, or do you want me to consider appointing one for you if you qualify?
No. Honestly, I did not, not going to do anything to hurt her. I love her.
Okay, well, she's fearful of you because of your behavior, and you're not to have any contact with her. So that's what this case is about. But I entered a not guilty plea until you can visit with the lawyer about the case. Are you going to be able to hire one?
I never did see her even after we separated. I have not seen her.
Can you hear me?
We can hear you, Your Honor.
Okay. Are you going to hire an attorney, or are you in a financial circumstance that you may qualify for court-appointed counsel? You need an attorney.
Well, I thought I had one. I've been talking to one. I've been hard to catch him all the time.
Okay. Well, if you have a domestic attorney, they may not do criminal work. There's no one here appearing, and no one entered on your case. So I'm gonna set your case over for you to visit with that attorney or to retain another one to represent you. This is Judge Hart's case. Judge Charles Hart. The court date he has scheduled for you is June 30th at 2:30. And you need to appear at the courthouse if you make bond. Otherwise, your appearance will be arranged just as it is today. Do I have a recommendation on bond?
Yes, Judge,
Here.
the recommendation is $5,000 cash or a surety bond. I don't know of any criminal history necessarily. There were multiple witnesses to the incident. They would ask that you put a GPS in place and emphasize no contact with the alleged victim.
I want to say one more thing. I'm talking. It's a recording hearing.
Sir, where do you live?
Well, listen, there's another thing, man. I have been and know that I have possibility of Agent Orange from when I was in the service. And I've got more hospital business coming up. I've got several things. I've been affected by it.
Okay, so what kind of financial monies do you receive from the service a month?
I don't see any. I've been trying to get stuff with the VA and it's been a while.
Okay. What is your source of funds to live every month?
What?
Every day? What's your source of funds? How do you live?
Well, my source of funds, money,
Yes.
Social Security, my retirement comes from when I was a Teamster truck driver, and one other. I happen to be the mayor of Rose Hill.
Okay. Well, I'm gonna set your bond at 3,000 cash or surety, no contact whatsoever with Kathy Weaver. And you must have a GPS so that she can have a device that would notify her if you're on her property or come around her in any way. So GPS, no contact, 3,000 cash or surety, court date with Judge Hart, 6/30/25 at 2:30, and you need to obtain an attorney to represent you by that date. All right, thank you, sir. We are adjourned.